What you need to know to win in the Alaska Small Claims Court, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. I'm Jordan Farkas, and grateful to all of those who have subscribed. If you haven't already subscribed, don't forget to hit that subscribe button and the notification bell so you don't miss a future video. Definitely helps me as well to continue to produce videos just like this one to help you win in the small claims court. If this is your first time coming to my channel and you wanted to learn a little bit more about me, feel free to check out my bio video on the homepage of this YouTube channel. In today's video, I'm going to discuss what you need to know to succeed in the Alaska Small Claims Court. This is the first of a series I'm going to be doing state by state for small claims courts across the United States of America. And in case you're wondering, I'm starting with Alaska versus Alabama because frankly, my research of Alabama Small Claims Court was proving to be a bit difficult. A lot of the websites were down. I'm not sure if that's because of the new year and those are being updated. In fact, even for Alaska Small Claims Court, a lot of the websites were down. Links to various forms and brochures were also down, but I was able to piece together a fair bit of information. And it's so much so that I'm able to produce this video for you that will hopefully give you some great tips and guidance to point you in the right direction. But that's why I'm starting with Alaska versus Alabama. So those of you from Alabama who are watching this, no disrespect to you, that definitely is in the plans as well, along with the other states of the United States of America. Now, without further ado, for those who have seen previous videos, you will know that I'm very old school with my whiteboard over here as I continue to try and get better and better at my actual video editing skills. Would love to do this incorporated in my videos, but hopefully the whiteboard gives you at least some additional visual to seeing what it is I'm talking about so that you can follow along. Of course, if you're watching this as you're doing various chores or listening to this as you're doing work or taking care of your kids or whatever the case is, then of course, no need to look up and see that whiteboard. You can listen to what I'm saying, but for those who are watching this, hopefully the whiteboard will be a nice visual. Now, what I've done here is I've got this broken down into blue, red, and green. The blue talks about the various procedures involving the Alaska Small Claims Court. Of course, I want to point out that there's only so much I can talk about in one video. So when I get into various procedures, I'm talking about more of the main procedures that accompany the small claims court in Alaska, but there are obviously other procedures that could come up. There could be motions that maybe come up, motions being some intermediate steps that one of the parties, i.e. either the plaintiff or the defendant, may take within a small claims court proceeding. I don't get into motions in this. I'm just dealing with more the general types of steps that accompany a small claims court case in Alaska. In red, I discuss some of the various locations within Alaska where you can find a small claims court nearest you. And in green is some general information that I wanted to make sure to point out for you before I go even further. So let's start with that green section here, which is kind of a general understanding of Alaska Small Claims Court. And the first thing that I jotted down here is that the Alaska Small Claims Court has a limit of claims of up to $10,000. Now, what happens, let's say, if you have a claim of $10,000, $10,500, for example? So you can definitely decide to waive the excess amount over the $10,000 limit in order to bring your case within the jurisdiction of the small claims court. A lot of times that involves a strategic decision. Maybe it makes more sense to go to higher court. Why should you give up on any hard-earned money? On the other hand, when you go to higher court, more often than not, you're going to need a lawyer to assist you, and then you have to pay legal fees, and you may not be able to recoup those legal fees, and therefore it may make more sense to go to small claims court as well. Small claims court is more streamlined. So not only is it easier for you to be self-represented in small claims court in Alaska, but also in terms of sheer dollars and cents, it may make a lot more sense to take something to the small claims court in Alaska versus the higher court. I think the higher court being the Superior Court of Justice, if I'm not mistaken. If I am mistaken, just remember, I'm a retired lawyer from Ontario, Canada, as opposed to Alaska. So take that with a grain of salt. But as I've said in many of my videos, a lot of the procedure, a lot of the strategies that go along with winning in small claims court, which again is the focus of my videos, will apply to courts across the spectrum, across the world. Okay, but strictly speaking, there may be a terminology or a definition that may vary from court to court. So forgive me if I get that portion wrong, but even if I do, that doesn't discount any of the other information that I'm sharing with you. So that's the first thing. The limit of the Alaska Small Claims Court is up to claims up to $10,000. Now, the next thing to point out, I mentioned the idea of lawyers. In the Alaska Small Claims Court, lawyers are allowed. So you may have representation from a lawyer in the Alaska Small Claims Court. Now, do you want to have a lawyer? Sure. In most cases, if it makes sense financially, you want to have a lawyer with you. But take the case, for example, where you have a claim of $2,000. Okay, and let's say the lawyer's fees are $1,500. I'm just throwing out examples. Different lawyers are going to have different rates, obviously, and you're welcome to check with a lawyer to see what sort of rate or retainer the lawyer is going to ask you for. But in a case like a $2,000 claim, it probably is not going to make financial sense to have a lawyer. But if you have a claim, let's say of $10,000, then it may be prudent to have a lawyer to assist you. And that's part of what you should be discussing when you're considering a lawyer. You want to ask the lawyer what their fees may realistically be from start to finish based on the facts of your case. Most lawyers will offer a free legal consultation, and therefore I would suggest taking that consultation with a lawyer to make sure you understand the full extent of your rights. Just bear in mind, there's only so much that a lawyer is going to provide for free. There are no free lunches, as the saying goes. So don't expect the lawyer to give you free legal advice, from A to Z or A to Z coming from Canada for your case. But certainly a good lawyer will be able to give you a good snapshot of what is entailed in your case and give you a good understanding of what your fees may run you to. Of course, small claims court cases, just like any other civil litigation case, can take many twists or turns. So it's usually very difficult for a lawyer to guarantee what their fees will be. You may find a lawyer that does, so that's always possible. But in most cases, lawyers can't promise you what their bottom line fees will be from start to finish. Another reason for that, by the way, as I'll get into a little later, is that oftentimes a lawyer may say, well, your fees will be this if you end up collecting on your small claims court judgment, assuming you win. There's never guarantees that you'll win, but there's also never guarantees that you're going to be able to collect even if you do win. Okay, so the collections process may be a completely different procedure from the small claims court process. So go through this video, make sure you have a general understanding of how it works, and therefore you're that much more educated to ask the right questions of an attorney if you are in a position where you are considering having an attorney to help you with your small claims court case in Alaska. And the third thing that I jotted down here is that when you go to trial in Alaska for small claims court, the evidence that you submit must be by way of witness. Okay, so I've talked in earlier videos about the idea of evidence and what that includes. And generally speaking, that includes documentary evidence. So that could be invoices, photographs, receipts, things of that nature that you can document. And then you have the idea of witnesses, where witnesses will testify on your behalf. Now, from what I read, even if you want to rely on documentary evidence, that has to be introduced by witnesses. Now, I'm assuming that you yourself can be a witness for your own case. So you can say, I had a contract with such and such person on such and such date, and here's a receipt that I'm introducing to the court. It doesn't always mean that you need to have a separate witness, but obviously having independent witnesses to verify and corroborate your evidence, to corroborate the documents that you want to rely upon is always a good idea. But bear in mind, from what I read, you must introduce your evidence by way of a witness. You can't just submit documents and not say a word at trial. You have to actually have testimony, that is what the witness is going to say at court, to provide the court with the documentary evidence that you want to rely upon. So those are some general headers. And now moving over, I'm kind of going right to left. Now moving over to some jurisdictions or some courts within the jurisdiction of Alaska. So from what I gathered, there's a small claims court located in Anchorage. By the way, there could be more than one, depending on where your closest court is to you. But generally, Anchorage, Fairbanks, Juneau, Kenai, sorry if I'm pronouncing this wrong, and Ketchikan. Okay, those are some of the different jurisdictions or different locations of small claims court. There are definitely more. And once again, the website for the Alaska Small Claims Court was down at the time of this recording in January 2025. And I'm not sure if that's because of an update for the new year, or if in general the website hasn't been updated in a long time. And that I know can present a challenge for you. If you are living in Alaska, as you watch this, maybe you know of more resources that you can look up to try and find out where the jurisdiction nearest you is. And by the way, the jurisdiction of the small claims court where you file is important, because generally you should be filing where it's most convenient for the defendant, for the person that you're suing. I'm assuming for the purpose of this video that you're the plaintiff, that you're the one suing. Okay, obviously if you're the defendant, it's also helpful for you to understand the procedure and how it works from start to finish. But I do intend on doing videos from a defendant's perspective as well. But a lot of my videos have been geared more towards plaintiffs, because the reality is those who are doing searches online usually will be plaintiffs looking how to win in small claims court, or they're considering filing a lawsuit, whereas defendants are more kind of reacting. They're responding to small claims court lawsuits that have been filed against them. Okay, another idea may be that if you're close to one of these cities that I mentioned, you can look up the nearest small claims court to you, or maybe it's not even necessarily the nearest. It may be a bit of a journey to get to that court, but when you get there, you may be pointed in the direction of where a more local court is. Another idea is if you're calling a lawyer for a general consultation, maybe that lawyer can tell you where the nearest small claims court in Alaska closest to your city is. Okay, so just bear in mind that knowing where you should be filing within the Alaska small claims court system is also very important. Now moving over to the procedure, which is in blue. So how does it work in small claims court? How do you start the process? Well, the number one thing is that you have to fill out. By the way, just before I'm interrupting myself, one other thing I wanted to mention is with all my videos, this is always subject to being updated. The small claims court limit may increase. As of today, it's $10,000. That may increase. So you should always do a search to check to make sure that maybe some of the information has to be updated. So if I'm saying 10,000, you want to make sure maybe now it's 12,000 by the time you're watching this. Also, as things become more and more digital, it may be that a lot of these forms are done digitally. Maybe things are filed digitally. Maybe that's one of the reasons why the small claims court websites that I've been looking have been down. Maybe they're being updated to make everything more digitalized. So I'm saying you can go to the small claims court to check it out, but it may be that these things can be done online. Certainly there may be contact information that you can email or contact court staff without having to actually physically go there. You know, as we become more and more technological with each passing day, especially when it comes to AI and all that stuff. But in any case, for the purpose of this video, I'm going with the assumption that you have a court that you can go to find out this information. And by the way, I did notice that there is a small claims court handbook for Alaska. But again, the website or the PDF that comes along with that link, unfortunately, was down. I don't know if it's because, again, I don't know if it's because it's being updated or whatnot, but that could be an excellent resource, I would assume. If only I could have seen it by the time I'm doing this video. Okay, so back to where I was in the procedure. The first step is to file the complaint. Okay, that's the document that sets out what it is you're owed, how much money, why you're owed the money, who the person you're suing is, who the defendant is. That's the first document. And this is a very important document because it tells the story. That's the first document generally that a judge of the small claims court in Alaska is going to read to form their impression of your case. So make sure to take the time to present a good chronology of what happened and when. And in fact, I wrote down here that you can actually attach supporting documents to the complaint, which is similar, by the way, to the small claims court in Ontario. As I was saying before, there's a lot of overlap between courts around the world. So you really want to put your best foot forward to attach your supporting documents. Again, it won't be reliable as evidence until you actually have a witness who introduces it at the trial, should it get to a trial, but certainly put your best foot forward and attach that supporting document. Okay, that's allowed to be done in the Alaska Small Claims Court. Now, along with the complaint form, what you attach as well is what's known as a summons. That's the document that informs the defendant that they're being sued and that they have to appear before a judge at trial, assuming it goes to trial in the Small Claims Court of Alaska. And the third document that you attach is called the answer. Okay, the answer, you just fill out the header, but you don't fill out the actual form because the answer is something that the defendant fills out. That's the defendant's response to your claim. And in fact, the defendant could even do a counterclaim. If the defendant feels that not only do they not owe you money, but that you owe them money, the defendant can counterclaim against you. And their counterclaim, of course, has the same limit that your claim has. So the counterclaim is for a maximum of $10,000. Although you should note that if the defendant feels that they're owed more money than $10,000, it's possible that the defendant will move to bring the entire matter to the higher court and take it out of small claims court. So you should always bear in mind before you sue, is there a possibility that the defendant may actually counterclaim against you? And then you may find yourself with a higher court claim, and then you may have to get into attorneys, even if you didn't plan on having one, and incurring those legal expenses. So these are the types of considerations you have to make before you even file your case. As well, you should also consider things like the statute of limitations. There's typically time limits for when you can actually file a claim from the date that the events in question occurred. The run period, the time that the statute of limitations begins to run, will depend on the various laws and rules in your jurisdiction. So again, that's beyond the scope of this video. Hopefully in the future, I'll be able to get more into that state by state, but it's a big endeavor. There's a lot of states to cover. But for now, just bear in mind that oftentimes there can be a statute of limitations. There probably is. And that's another good question to ask a lawyer when you give the lawyer, if you do go with that consultation, to ask the lawyer when the statute of limitation begins. And if you've missed the statute of limitations in many courts, that precludes you from actually filing. Or if you file, it may be a case where the defendant can simply get your case dismissed because you missed the limitation period. Oftentimes it's a gray area, so it really depends on the rules of your local jurisdiction. But just be mindful of the idea that you do have a time limit for which you have to file your claim. Now, when you prepare these documents, you then go and you file it with the small claims court, and the small claims court will assign you a number, okay? Then you have a court file number for your small claims court action. And again, I mentioned before, I wrote down over here about the defendant's jurisdiction. Just remember that typically you're supposed to be suing where it's actually convenient for the defendant, which typically will mean where the defendant resides or carries on business. Again, that's another good question to ask an attorney. What would be the right jurisdiction for filing in the small claims court? But the point is that you file these documents, the complaint, summons, and the answer with the court. You get a file number, and then you have to serve it on the defendant. You have to provide that to the defendant. Now, how do you do that? Well, in many cases, and from what I believe from reading what I read about the Alaska Small Claims Court, that has to be by registered or certified mail. Another effective means of doing so is to hire a process server to serve it on the defendant directly. Okay, that means you're hiring a person who goes and provides that to the defendant. And then once these documents are served or provided to the defendant, you have to file, or if you get a process server, it could be that the process server has to file for you as part of their service, what's known as an affidavit of service. The affidavit sets out how and when you served the defendant with the documents. Now, I want to point out again that there is a website that contains all the different forms of the Alaska Small Claims Court. But again, I know I sound like a broken record. Unfortunately, this website containing all these forms was down at the time of me preparing and recording this video. But I will link in the description below to this site that contains the forms. And hopefully by the time you're watching this, that will be up. And I also intend on linking to some other websites that can provide useful information. If they are down, again, forgive me for that, but that's what I incurred as well. But some of the websites that I did glean information from are up as of this recording and hopefully can point you in the right direction as well. Now, after you've filed the affidavit of service, the defendant will then have a specific amount of time based on the rules of the Alaska Small Claims Court to file that answer, okay? And you will be notified of that answer, or you're supposed to be anyways. I do suggest if you haven't received an answer within a certain period of time, again, check what the rules say about what the time limit is for the defendant to respond. And if the defendant hasn't responded, then what you can do is that you can seek what's known as default judgment. Default meaning the defendant is in default. That's item 4 I listed below here. The defendant is in default for failing to file a defense on time. Now, what happens in the case of default judgment? So depending on the nature of your claim, it may be, and again, this is something that you can consult with an attorney in your jurisdiction, it may be that you still have to go ahead to an attendance before a judge to actually prove your case. That's the case in Ontario. Or it may be that you could simply ask for judgment immediately from the Alaska Small Claims Court, even over the counter, so to speak, from the clerk of the Small Claims Court in Alaska. Check with the jurisdiction, check with the clerk when you're preparing these forms to determine what the procedure is there for default judgment. Of course, if the defendant does file the response, the answer within the requisite period of time, then what's going to happen is that the judge will then assign for you a trial, okay? And once again, check if you can give your available dates. So in Ontario, for example, I know I reference Ontario, that's my frame of reference, but again, there's a lot of overlap. You can ask the clerk to not schedule a trial for various specific dates if you already know of dates in the future that you're not available. Of course, the court may or may not listen. They may go ahead and schedule for a date that you're not available. If that happens, you may have to bring that motion that I was talking about before, that interim proceeding, where you're asking for an adjournment. You're asking that this trial date be pushed off because you're not available, or you may have to push off other, pre-arranged scheduling conflicts to make sure you're at court to be able to ask for that adjournment. In some cases, you could send somebody to notify the judge at the trial date that you're not available, or you can ask the defendant themselves if they're agreeable to adjourning the scheduled trial date. It's getting a bit beyond the scope of this video, but just know that there are steps that you can take to try and alleviate any concerns you have about scheduling conflicts. But assuming you get a small claims court trial date that works for you, then you get ready for your trial. And getting ready for your trial, I wrote here, may mean doing what's known as a subpoena, okay, a subpoena to witnesses. Okay, so let's say you know of certain witnesses that you want to be at your trial, and I get into witnesses a lot in earlier videos, and I do suggest that you go ahead and watch those. But let's say you want to have a certain witness at trial and you're not sure that the witness will agree to be there, then you can issue a subpoena with the court and provide that subpoena to the witness to make sure that they will be at the trial date. And if they're not, that is considered in most jurisdictions to be contempt of court. Of course, you have to consider if you have to subpoena a witness, that may not be the most friendly witness to you. That may be a hostile witness, and that may not be a witness that you want to have at court. But the reality is, in some instances, if you cannot secure that witness, the only way to do that may be by subpoena. And also, if the witness doesn't attend, you can at least show to the judge that you tried. It's not like you didn't try to have that witness there. So subpoenas can be a strategic move in your favor, but also bear in mind, if you have to get to that point, that may not be the best thing for you, because effectively it means that the witness may not be that friendly. Okay. And of course, the ideal is to have witnesses that are on your team and that are ready, willing, and able to testify and will be at the trial for you. Now, once you have the small claims court trial, I've gone at length to talk about what happens at trial. You have the chance to present your evidence. Your witnesses present evidence for you. The defendant has a chance to cross-examine your witnesses, to ask them questions to try and disprove your case. You have a chance to cross-examine the defendant after the defendant has called their witnesses, etc., etc. And then the judge is going to make a decision. I should mention before, something else that I read is that in Alaska small claims court, the judge may suggest possible mediation, possible attempts at settling the case. And I do suggest that you strongly listen to what the judge is telling you, because the judge is the one who's going to be making the decision. If the judge feels you're being unreasonable, or if the judge is kind of hinting, maybe even saying straight out that you're not going to win your entire case, then you should definitely consider that. And also remember that even when you win a trial, it doesn't guarantee that you'll actually collect on the judgment. You may have to proceed with collection. And if the defendant doesn't have assets, then it may be very hard to collect from the defendant. And whether or not the defendant has assets is something you should consider even before you file your claim, which I talked about, I think, in one of, if not my very first video. So that's part of the considerations you should make before filing. But even if you haven't considered that and you're at the point where you've won in court, you may not actually collect on that judgment. So settling a case out of court can be very advisable, especially if the judge is advising it, even if it means you're not collecting 100 cents on the dollar. As the saying goes, a bird in the hand is worth two in the bush. Okay, although there are instances where even where you have a settlement, the defendant fails to pay. And oftentimes what I've done strategically is to structure settlements that say that, okay, the settlement will be for $5,000, but if the defendant fails to pay under the settlement, then it goes to immediate judgment of $10,000. Okay, those are more lawyerly types of things. And that's the reason why it can be helpful to have a lawyer. Of course, if you're talking about a much lower claim or if you're going to be self-representing yourself, structuring settlements like that may be a little bit more challenging, but that's something you can learn from a video such as this. And finally, as I mentioned, as I alluded to, even if you win in court, you may not collect for two reasons. Either the defendant isn't paying, or the defendant may actually appeal. And again, I believe the appeal is to the superior court in Alaska. So if the defendant appeals, then that prolongs the case, and then you find yourself in higher court dealing with an appeal. Okay, that's another risk you have to contemplate before you file. Do you have the wherewithal, the time, the energies to start dealing with appeals? I would say in more cases than not, defendants do not appeal, because the defendants, just like plaintiffs, don't want to deal with appeals. By the way, the defendants are called the debtors or judgment debtors after you've won a judgment against them, and you as the plaintiff are called the creditor or the judgment creditor. But the defendant or judgment debtor certainly has the option of appealing. The defendant and judgment debtor has a certain amount of time to do that. But bear in mind that there may be an appeal. And also bear in mind that if the defendant does not appeal, but also has not paid you, then there are enforcement mechanisms. And the main enforcement mechanism that I saw for the Alaska Small Claims Court is known as a writ of execution. A writ of execution is kind of like a lien that you can place on the defendant, such that the defendant's assets would go to you before any other creditor. Okay, so for example, if the defendant has property, again, assuming no jurisdictional issues, and that's beyond the scope of this video, I talked about it in an earlier video, assuming no jurisdictional issues, and that assuming that the defendant has a piece of property in the jurisdiction where you sued, the writ of execution can really stop a defendant from selling that property because people don't want to purchase properties with writs, or it may make the defendant eventually sell that property, rather pay out the judgment before the defendant sells that property in order that the defendant could sell the property. So the writ of execution enforcement mechanism can be very powerful, but not always. Defendants aren't always in a rush to sell their property, so that's something that can take years. And in many courts, you have to continue to renew those writs of execution. Again, check with, you can ask an attorney in a consultation in Alaska, or check with the rules of procedure in Alaska, or check with the small claims court how it works with respect to writs of execution. But bear in mind that there are enforcement mechanisms in place in the Alaska Small Claims Court in the event that the defendant fails to pay. Okay, so that concludes this discussion of succeeding in the Alaska Small Claims Court. I hope you found that helpful. I do understand that I can really get into the weeds and drill down a lot more, but I am not a licensed attorney in Alaska. I have not practiced in Alaska Small Claims Court, so I don't want to get into too much strategic decisions. The point of this was more to give you some general guidance and tips as to how the procedure works, while sprinkling in a lot of different things that I've experienced based on my small claims court experience from Ontario, Canada. But hopefully you can apply that, and hopefully that informs you so that if you do consult with an attorney in Alaska Small Claims Court, which I do recommend, you're that much more educated in order to ask the right questions. And if and when you do proceed to file your case in the Alaska Small Claims Court, if nothing more, this gives you a good head start. If you have any comments or questions, feel free to leave that in the comments section below. I'm always happy to hear your feedback. And as this channel is in its infancy, there's a pretty good chance I'll actually respond directly to your comment, of course, assuming that it's respectful. And also, if you know of anybody who's dealing with an Alaska Small Claims Court issue, feel free to pay this forward by sharing that with them. If there's a topic you'd like to see me discuss, not necessarily related to the Alaska Small Claims Court, about Small Claims Court in general tips or guidance, feel free to leave that in the comments section below as well. Once again, if you have not yet subscribed, I would be very grateful if you did that. And if you hit that notification bell, you won't miss a future video to help you win in Small Claims Court. Thanks once again for visiting and for watching. And until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your Small Claims Court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your Small Claims Court lawsuit.